Hi there. In this video, we're going to talk about the law of patent inventorship. Patent inventorship is important because it's the inventor of the invention that's the owner of the initial patent rights covering that invention. Inventorship is also important because it's a pretty strict standard and it's dictated by the law. It's not up to the discretion of the inventors. You can't name someone as a joint inventor of your patent as a favor to that person. There's consequences to improperly naming the inventors of a patent. That is, your patent rights could be unenforceable because you named the wrong inventors, or investors could be scared away from investing in the development of your patented technology. So let's take a relatively simple example. Pretend there's an orthopedic surgeon who understands through years of performing surgeries, installing knee implants in patients, that existing knee implant technology does not work as well as it could because the knee implants don't always fit into the patient's bone structure. Orthopedic surgeon talks to engineer one, who conceives in his or her mind of a new knee implant system that could make it easier to fit knee implants into patients. Engineer one doesn't actually build a prototype or build a product, but is capable of writing down what this invention would generally look like. Engineer one talks to engineer two, who spends 2 days straight in the prototype lab actually building the prototype of this knee implant system. So under patent law, who's the inventor of an eventual patent covering this knee implant system? Is it the orthopedic surgeon that identified the problem? Is it engineer one who conceived of the solution? Or is it engineer two who actually built the product and the prototype? Well, under patent law, the inventor of this invention is engineer one, the person that conceived of the solution. Under patent law, conception and therefore invention is defined as the formation in the mind of the inventor of a definite permanent idea of a complete and operative invention as is thereafter to be used in practice. One is not required to actually build the product or the invention. They just have to be capable of describing the invention in enough detail that people in the field could understand how to actually use it. So as you can tell, the law of inventorship can be a little confusing and can really differ depending upon the specific facts in your scenario. Sometimes it's easier to understand what does not amount to inventorship. As you can tell from an example, merely building a prototype or reducing an invention to practice does not by itself equal inventorship. Merely supervising inventive activity, no matter how smart you are, no matter how senior you are, that does not equal inventorship. Contributing labor, working really, really hard, that by itself does not equal inventorship. Funding the development of technology or the inventive activity, even if you contribute millions and millions of dollars, that by itself does not equal inventorship. Deriving a solution to a problem where you don't have enough detail about that solution, that does not equal inventorship. I could come up in my mind with the idea of a rocket ship to Mars, but unless I could actually describe how that rocket ship is going to work, I have not invented that rocket ship. Identifying a problem, like the orthopedic surgeon did, that by itself does not equal inventorship. Performing experiments that show how an invention is actually going to work, that by itself does not equal inventorship. Also, the claims in the patent really matter. You're not the inventor of a patented technology unless your contribution to the conception of that invention is actually covered in at least one of the claims. Therefore, conceiving of an invention that's not actually claimed in a patent does not equal inventorship. So as we discussed, inventorship is critically important because it's the inventor that initially holds rights in patented technology.